Our first speaker today is Brett Johnson. Brett is a former Judge Advocate General with the Navy and is now a partner with Snell Wilmer in Phoenix. Brett is a specialist in government relations matters and advises clients in international transactions, compliance, export, government contracting, and is also a commercial litigator. He specializes in helping clients through government investigations, defending False Claims Act cases, Foreign Corrupt Practices Act cases, and government procurement and compliance. And he also helps his clients by doing training in those areas as well. Here to help us understand when it might be time to air the dirty laundry is Brett Johnson.
Good morning, everybody. Glad to see everybody here early for a great presentation for the rest of the day. So we're going to talk today about voluntary disclosures to the government, one topic that usually is left on the wayside when you're kind of developing programs throughout the company. But the importance of voluntary disclosures just cannot be missed in this day and age. Because as we, as trial attorneys, think often, wouldn't we like to tell the story over again from the beginning? And we miss the opportunity in many cases when we're developing a voluntary disclosure of setting the story first off. So as we begin today, understanding why voluntary disclosures are important, understanding the voluntary disclosure process, and there is a process, and then some best practices related to voluntary disclosures that hopefully you can take back to your practices and your clients. The big thing about importance of voluntary disclosures is it actually required by statute, regulation, or contract clause? Now, we all have our personal Fifth Amendment rights, but Fifth Amendment rights do not apply to corporations. So, are there regulations, statutes, or even contract clauses that are out there that require us to disclose? If you're a government contractor, in many cases, there is a clause inside the government contract or inside the grant when the government is giving you money to have an ethics compliance program. As part of that program, the contract requires that if there's credible evidence that there is fraud, waste, or abuse on the government, that you have an obligation to voluntarily disclose. So keep that in mind, that it's not just statute, regulation, and contract, but the contract clause itself is important. When I say statute, that's usually in regard to export controls, in that you have to make sure that you're not doing business with bad people. And if you do, in certain cases, i.e. China, which has been on the radar screen for many years, but a lot of people are doing obviously quite a bit of business there, if you sell something to China and it's not allowed, there may be an obligation report by statute that you have to keep in mind. Is there a mitigation rationale for the voluntary disclosure? A lot of people fail to appreciate, especially business folks, why would I possibly tell the government that I did something wrong? Let the government come and tell me I did something wrong and I'll respond accordingly. But by doing so, you lose the mitigation ability in dealing with the government on the settlement process or even in litigation or sentencing down the line. Also, especially for export controls, government contracting, False Claims Act type cases, there are directed disclosures. The government finds out about something, puts a letter in the mail and says, respond to X, Y, and Z. And then during that process of trying to gather the documents and gather the information that the government is looking for, there was something else that it was wrong. And you find that out. As part of that process, do you want to make a voluntary disclosure separate from the directed disclosure because they're unrelated, but more likely than not, if the government is going to pursue the Voluntary Disclosure Act or the directed disclosure, they're going to follow on and find what would be otherwise disclosed during the voluntary disclosure. We've heard a lot this weekend, and we're going to continue to hear a lot about whistleblowers or rogue employees. It's real, and we're going to go over a case study that discusses that. And finally, reacting to enforcement trends. As part of the government's process, there is an increased investigation and audit requirements where the government is coming in from a variety of different agencies, from the Department of Labor to the Office of Inspector General to contracting officers who are constantly doing audits and investigations into the work that you're doing either on behalf of the government or in compliance with a government regulation or a law. Now there's a significant pooling of resources. We've all heard about government shrinking. So unlike back in the historical turf battles where agencies did not get along, especially either across borders internationally or even across agencies or state versus federal domestically, there is now a significant pooling of resources. Now, we're all lawyers, or most of us are lawyers. There is no right or Miranda right in China. So when the Chinese government and the U.S. government get together and decide to investigate cases, they are going to take your executives and wait till they go to China for a visit to be able to do that interrogation, and I guarantee you it's not a pleasant experience. So you have to appreciate that there is a pooling of resources and that the investigations are going to significantly increase coming up. Data mining is a major area. If you're in the healthcare industry primarily, that is a significant area where the government is reviewing medical records. They made a big push for electronic medical records. Yes, it's all great for our healthcare, but it's also great for data mining. The big significant cases that have come out recently in regard to false claims acts in the healthcare industry has been in data mining. That has now been passed on to export controls, because in your export controls, a lot of that is going electronic, and the government is data mining that activity to ensure that wrongdoing is caught. Previously, if you wanted to do a civil investigation demand on a company, you had to go all the way up to the United States Attorney General to be able to get that happen. Now that has been delegated to the U.S. attorneys. So at the local level, companies are seeing these investigative demands from the government to respond to different activity, which has increased, obviously, the cases. We talked about the increased audits. Now, Washington is Washington. Nobody really gets along. But one thing they get along on is in regard to going after wrongdoers. As taxpayers, nobody wants their taxes increased, but nobody is going to complain if a company gets hit with $1 billion fine because of wrongdoing. But if our taxes go up, it's definitely a significant problem. So as part of President Obama's budget, which still hasn't been passed, there has been a significant increase, 30% increase recommended for both audits and investigations at every different level. Department of Labor, Department of Health and Human Services, Department of Defense. Why? Because basically for every dollar that they put into investigation, they get $5 back in fines. That's a significant amount of money that the government does not want to pass over. Okay? For the Affordable Care Act, they're actually putting now in statutes, if you're a contractor, that you have to do audits, or if you're administering government contracts, you have to do audits on your subcontractors, or for medical people, your healthcare practitioner networks. Those audits are only going to increase because the administrators are not going to be held on the line for something that a provider does. So as part of that audit requirement that is going across the government, not just in Health and Human Services, you're going to see an increase in actions. Finally, the key TAM lawsuits, which we talked about, it's not just the rogue employees. We're seeing competitors bringing key TAM actions against other people and winning. That's definitely a good bottom line increase if you're getting a piece of that key TAM settlement. Okay? Finally, on the shareholder derivative suits, this goes back to mitigation. If you're a public company and you had an opportunity to voluntarily disclose, you knew about the problem, you didn't, the government found out about it, they came after you, and you were not able to mitigate by 50% the penalty that the government gave you, that is setting up a shareholder derivative action. Here's a case example. United Technologies is from 2012. It has a lot of the issues that I've talked about. It voluntarily disclosed ITAR violations going back to 2002. Again, China gave software to China for military attack helicopters. That's bad. The criminal charges, these are actually the counts. I abbreviated, obviously. Illegal export, we get that. These are criminal counts, by the way. Illegal export. Lying in the self-disclosure, and 3, a belated disclosure because there was a mandatory requirement. Once they found out about it, they were supposed to tell the government. They did not do so. So there was an actual charge there that they did not disclose properly. The lesson learned, the voluntary disclosure was done during due diligence on an equity deal. They discovered it. They did make a voluntary disclosure. They also lawyered up in regard to making the voluntary disclosure. And yet, they still got caught for lying and not making it in a timely fashion. So the concept was the rush disclosure versus getting it right. And this is something that it was a significant consequence because there was a guilty plea for a company, which is very rare, but it is happening more and more, for Pratt & Whitney Canada, also an export suspension, had government contract implications, and for many companies, that's a death sentence. So deferred prosecution agreement for some of the other subsidiaries and related companies, including the parent company, and $75 million and a monitor for 2 years. Now those monitors, if you've ever had an experience with them, they're not cheap. It's usually somebody like Louis Freeh or somebody along those lines, and you're paying for them, and you have no choice, and they're in your business every day. Okay? Good luck challenging his bill. All right. Apologize here, skipped. This is a more recent case, actually an Arizona case, Carondelet Health Network. In 2010, an internal audit found documentation was lacking to fully support the billing of inpatient rehab services, and they voluntarily disclosed. They implemented new procedures, put together a mitigation plan, and they gave back to the government $24 million, which, under the Affordable Care Act nowadays, there's a requirement to give them, if you know there's something wrong with your billing, in 60 days you have to give that money back. So again, the forced disclosure we talked about. Well, the person who did the internal compliance, who was not a lawyer, felt like the disclosure wasn't good enough. So she went out and she brought a whistleblower action in 2011. And as part of that, the AUSA picked up the case from the key tam, determined that the initial voluntary disclosure was not timely, complete, or adequate, and settled for $33 million. Now, a few months ago, I gave a similar presentation to the certified fraud examiners in Arizona. It's about 100 people there. She was there. She was a company employee, not anymore, and they gave her a standing ovation. Internal certified fraud examiners for companies throughout America, not just the consultants. These were in-house people, and they gave her a standing ovation. Now, I would like to think in my heart that it was moral and everybody thought, great, somebody finally stood up, etc. But I want to know how many other people actually thought, gosh, wouldn't it be great to get a piece of $33 million? Okay? So that is the mentality of non-lawyer compliance people, especially in this day and age when it's so easy with the plaintiff's bar switching over to do key tam actions. So keep that in the back of your mind about employees who are actually doing your compliance and etc. Now, one thing I'd like to point out, if that was a lawyer who did that investigation and took care of that voluntary disclosure, they would be ethically bound not to do the whistleblowing because of the attorney-client privilege. Consultants do not have that ability. They don't have the privilege initially, and yet, and you don't have this risk on the back end. But so many people nowadays are using consultants rather than lawyers, internal lawyers or outside lawyers, to do voluntary disclosures. There is no privilege, and the government loves it. Okay? So when you're saving $200, because usually that's the range, when you're saving $200 by using a consultant, please keep that in mind. Voluntary disclosures, it's not just the act, when the act happens by itself. This is well before an act occurs. You have to have your policies and procedures in place, you have to have your agreements in place, and you have to do training on it. These are things that the government wants to know about well before you have to voluntarily disclose. If you're rushing to do this during a voluntary disclosure, yes, it's good, don't get me wrong, but it might be too late, okay? In addition, as part of this policy, there has to be a program that actually understands the statutes and the contracts. Now, a lot of government contracts are about this big, and then they make citations to a bunch of regulations that you have to go find to figure out that are going to be applicable. You have to truly understand what you're getting into. Again, we talked about well-drafted agreements with both your employees as well as your third-party consultants. Finally, training and audits. Now, audits are going to be more and more required. If an audit discovers an error, you really seriously should consider voluntarily disclosing. Finally, we talk about hotlines, which is a major issue that the government is looking for. And an overlooked piece of this is employee exit interviews. If you're going to be a whistleblower and you had an exit interview on your way out and you did not raise the issue that for which you want to go be a whistleblower for, that's pretty significant. So there's a missed opportunity when HR does not take exit interviews on their employees and truly track what is going on. Okay? Post-event, obviously we all know about the preservation memo, get some counsel early, the internal investigation, which we're talking about today also, but understanding the regulations and guidelines associated with the voluntary disclosure. So each agency has regulations usually on point as to how to do a voluntary disclosure. That should drive the internal investigation in many ways, because you're going to want to make sure you understand those regulations in case you do decide you want to voluntarily disclose. Now again, evaluating whether or not to disclose. Again, sometimes it might be mandatory. If you know a whistleblower is going to come out, you want to set your facts together. In addition, in the middle of litigation, it's an employment case, etc., and the employee blurts out during the deposition this wrongdoing that is occurring with the company, okay? It's never too late to do that voluntary disclosure. And we've done that very effectively before. Is in the middle of litigation, an issue has arose about possible wrongdoing. It actually has had absolutely no merit, which a lot of these do on the whistleblower cases. And you go do a voluntary disclosure, the government sends you a thank you, we're no longer following the case. It would be 10 times different if there was a disclosure or a whistleblower case on the other side and they're setting the factual case. Evaluating when to disclose. Other events, again, will impact the decision. The federal sentencing guidelines and other regulations provide mitigation. Those are things you should keep in mind. And then as part of your voluntary disclosure, which I see companies that do it internally all the time, they forget to ensure that of keeping the right to supplement. Just in case the government finds out something, you want to say, yeah, I knew that, and here I'm going to supplement it. And you're trying to draw that back to the initial voluntary disclosure to make sure you get the mitigation. So don't forget to maintain the right to supplement, right? Finally is the request for confidentiality. FOIA is a powerful tool. The VA just sent out guidelines just last week on how they're handling FOIAs for competitive data. This is what your competitors want to find out about you to cause havoc within the marketplace. And they want to find out your pricing and whether or not you guys are good business folks. So you want to request confidentiality as part of any voluntary disclosure. Now, when we get to the government investigation itself, the government is going to come back and ask for additional information. It happens. But again, that might also be proprietary information, might be even outside the scope of the investigation. And so what you really want to do is enter into an NDA or some other type of agreement with the government that they're not going to disclose your information that you're providing to outside the government. Or, especially if you're a government contractor and they want the emails between internally about the contracting officer, and we saw the presentation yesterday about the emails that go back and forth. Talking bad about the contracting officer in emails, that's really bad for business. So keep that in mind when you're wanting to disclose that negative information to the government, because I guarantee you the agent is going to show it to the contracting officer. Tolling agreements, it's pretty much form. As you can see, these cases go well beyond the statute of limitations. Cooperation is key to prosecution decisions. You have to do a strategic waiver of rights, and on the Department of Defense form, for example, it says, will you waive your internal investigation that was done by your attorney? I never do, but there might be a case later on in the investigation that I'd follow up. Finally, the changing decision is a corporate death penalty. When you're making the decision to voluntarily disclose, you're making a commitment to cooperate with the government and get this put behind you as quickly as possible. Changing that decision and have a principled case, that goes too far. It could be a death penalty because now you're changing the perspective. So that is all I have. Thank you very much.